Okay, well, thank you to everyone for joining the webinar. I'm going to wait about 15 seconds to allow more folks to come into the room, and then we'll start with introductions and get this started. Okay, we still have people joining, but I think we've got a lot to talk about, so I think we're gonna get started. So welcome everybody to today's discussion, Labor in the Courts, How Unions Have Stood Up for Workers' Rights During the First 100 Days of the Trump Administration. This is co-hosted by the Ash Center for Democratic Governance and Innovation at Harvard Kennedy School and the Center for Labor and a Just Economy at Harvard Law School. I'm Sharon Block. I'm the executive director of the Center for Labor and a Just Economy and a professor of practice here at the law school. So before we get started, I just want to go over some logistics. Please note that today's discussion will be recorded. A link to the recording will be emailed to all registrants after the event, and you'll also be able to find it on the Ash Center's YouTube channel and a link to it on the CLJE website. We will reserve time towards the end of the hour to respond to your questions, so you are welcome to submit any questions using the Q&A button at the bottom of the screen. I think today's conversation is a really important conversation, an extension of lots of conversations that have been going on about how different civil society institutions are holding up during the first 100 days. And I'll just say, I don't think enough attention is being paid to the incredibly important role that labor is playing in defending democracy during these first 100 days. So I'm looking forward to hearing from our experts. So now I'm pleased to introduce our moderator for today's discussion, Professor Ben Sachs, who is the Kestenbaum Professor of Labor and Industry here at Harvard Law School and a leading expert on labor law and labor relations. He also serves as the CLJE faculty director and teaches courses here in labor law, employment law, and social change. And much of his writing focuses on union organizing and the role of unions in politics. So he's the perfect person for me to hand over this discussion. Thanks, Ben.
Thank you so much, Sharon, and thank you for everyone. Thank you to everyone who's joining us today. I'm thrilled to have the chance to moderate this discussion, largely because of our amazing panelists who have taken time out of their incredibly busy schedules to join us for this discussion. They're busy in large part because of the incredible work that's been undertaken since January. And I'm really looking forward to having a chance to learn from each of them. So briefly to introduce our panelists, first, Seema Nanda is a fellow here at the Center for Labor and a Just Economy. She's the former Solicitor of Labor in the Biden administration. Seema spent nearly 20 years in government at the Department of Labor, the Civil Rights Division of the Department of Justice, and the National Labor Relations Board. She's served in leadership positions at the Obama Labor Department and the Civil Rights Division, and has served as the Executive Vice President and COO of the Leadership Conference on Civil and Human Rights. Craig Becker is Senior Counsel to the AFL-CIO, where he served as General Counsel from 2012 to 2022. Before assuming that position, Craig was a member of the National Labor Relations Board, having been appointed by President Obama in March 2010 and serving until January of 2012. Danielle Leonard is partner at Altshuler Burzon. Danielle's practice consists primarily of complex litigation. She's represented international, state, and local labor unions, environmental groups, and other advocacy organizations, and workers, students, and consumers in class actions, cases involving diverse areas of law, including labor, employment, voting rights, and constitutional issues. She has briefed and argued numerous cases at the trial and appellate level in both federal and state courts. So thank you all for being here today. I thought we could start with Seema. And Seema, if you would just lay out for us as a kind of background table setting, what hiring and firing typically looks like in the federal government. Under normal conditions, how do workers get hired and fired by the federal government?
Sure. Thanks for that intro, Ben. And my job today is mostly to say before we get deeper into the litigators, none of what we're seeing, none of this is normal. So first, just to frame a little bit about who's in the federal government, I think when we think about a lot of the political appointees coming in, it just seems like we're talking about a lot of people. And I think one thing people are always surprised to realize there's actually a pretty minuscule number of political appointees. The federal government is largely run on a day-to-day basis by career civil servants. Just to give you an example of that, we had about 120, 125 political appointees at the Department of Labor for an agency of about 14,000 people. 14,000 when we left. We won't go into the numbers there now, but so we're just talking really small numbers. But usually, you know, when you hire someone, it's a process really geared around ensuring that the civil service is very much protected from political influence. So there's a job announcement, there's heavy career involvement with reviewing that, there's an HR specialist, there's a very in-depth interview and selection process. SES go through a special hiring process. These are senior executive service employees, the sort of top echelons of career people. They go through a separate process to make sure that they are qualified for the job. They have to go through an OPM has a board of people that sort of meet to talk about whether candidates have the requisite experience. And then probably more important for what we're talking about today, the firing process in the federal government. So most employees in the federal government have something called Merit System Protection Board protections. And those are really important protections that came about in 1978, but they really date back 100 years prior to that, to something called the Pendleton Act. And the whole idea of these protections is to make sure we don't have a spoil system in our government. We want to have a government that works, that's based on good government, that's based on people doing their work. So a few things to note that I think will be important for the discussion. Probationary employees have more limited merit system protection rights than employees who have been there longer. And they have a 1-year probationary period of that. There's also rules about the senior executive service. They're a little bit easier to move around. They can be moved within their agency without their consent because the idea is they're senior executives. They should be able to do a variety of these kind of leadership type of roles, but it can't be for retaliation or political favoritism or to punish them for something. And importantly, it can't be within 120 days following the appointment of a new agency head or new political leadership. So something we're also seeing happening. So in the federal government, normally when once you have the merit system protections really kick in for a particular employee, you have really detailed protections for those employees in terms of wanting to fire them. Notably, other than political employees in the federal government have for-cause protections, which most workers in the private sector don't enjoy. And that's for this very particular reason of making sure that we're protecting our federal government from this type of political interference. So that includes when you think you have a problem employee, they have to have an opportunity to be put on a performance improvement plan and then have a chance to meet those performance, very explicit metrics you're setting forth. There has to be a notice of proposed removal. They have a right to respond. And then they have appeals right to the Merit System Protection Board. There's also EEO rights. There's separate whistleblower rights that they sometimes have. But the larger point is it's really a pretty in-depth process. And as someone who worked in the federal government for a long time, it's something you're really trained on, and you think about how to really go through these steps because they are such important principles for how we run our government.
Okay, great. Seema, thank you for that background. And now if I can turn to Craig and ask Craig to give us a sense of what's been going on in the last 100 days in terms of sort of departures from the normal processes that Seema has laid out. And then also, if I could ask you to talk about the sort of the general landscape of litigation that unions have brought in response to these developments.
Well, that was a very good introduction to the good old days by Seema, because we're certainly not in the good old days anymore. I think it might be helpful to kind of, before going into the details of what's happened in the last 100 days, to lay out what I think are some unifying themes in those administration actions. And I think there are three. One is a centralization of power in the president. So not simply in the executive branch, but in the president. So this is in furtherance of what has been called the unified executive theory. And the notion is the Constitution gives the president power to ensure that the laws are faithfully executed. And the theory suggests that in order to do that, the president has to have authority over the entire executive branch, i.e. to fire anybody in the executive branch. And so the president is already, or this president has already, for example, fired numerous members of independent agencies, member of the National Labor Relations Board, the Federal Labor Relations Authority, the Merit Systems Protections Board, which Seema just mentioned, the FTC, and others. And as I'm about to talk about, going all the way down through the civil service that Seema just described, the president asserting his authority to fire. Secondly, a corresponding demand for loyalty over competence or fidelity to law. Just one little example. The Hatch Act is intended to ensure a non-political civil service, experts executing, administering law free of political constraints. So one of those who was fired by the president was the so-called special counsel, who heads up the Office of Special Counsel, which is intended to preserve the civil service principles that Seema described. President fired the incumbent, inserted an acting special counsel, and one of the acting special counsel's first act was to remove a restriction on the ability or a prohibition on federal civil servants wearing political paraphernalia on the job. So what's that's going to mean? You're going to see a lot of red hats when you walk into those federal offices. And if you see a blue hat, that person is going to soon be shown the door, right? So centralization of power in the executive, a premium on loyalty over competence, and a return to the patronage system, which the civil service was supposed to vanquish. What does it mean? If you're politically loyal, you get a job, RFK Jr., and you use those job holders to hold on to power. So the president has directed, for example, the Attorney General and the Secretary of Treasury to investigate Act Blue. That's what we're about to see, and that's what we are seeing. Third, I think unifying theme is using incivility, humiliation, and terror as tools of control. Right? Not on the level of the rhetoric and the actions that we're seeing in relationship to immigrants, but of a similar character and nature, to be sure. So repeatedly, the president, Elon Musk, and others calling people who've worked in the government for years and years and years corrupt, lazy, etc. So just last Tuesday, or just this Tuesday, in Michigan, the president called USAID, quote, a left-wing money laundering scheme, and said that many federal workers are playing golf and working a second job when they were supposedly working from home, and gleefully talked about firing federal employees. So humiliation and really terror as weapons of control. So what have been the weapons of destruction and what have been our responses? Again, let me just give you the categories. One, simply shutting down abruptly entire federal departments and agencies. Starting with USAID and the CFPB, as we all know, Elon Musk proudly proclaiming in February that he had spent, quote, spent the weekend feeding USAID into the wood chipper. Proceeding with others, Voice of America, the Federal Mediation and Conciliation Service, the National Institute of Occupational Safety and Health. These are agencies created by statute. Right? Congress created these agencies and endowed them with certain duties, mandated functions. The president cannot unilaterally destroy them or disable them from carrying out those functions. He also can't terminate and lay off federal employees without following the rules that SEMA described. And yet we are facing ongoing litigation agency by agency by agency because that's exactly what's happened. So for example, the National Treasury Employees Union obtained a TRO against the destruction of the CFPB, largely upheld by the Court of Appeals. And yet after those orders, there was a RIF ordered of 80% of the employees of the CFPB, 1,400 workers in one fell swoop, put on leave, locked out of their computers, and told that they were going to be terminated, leading to another injunction by the same district court. So right now, we're engaged in an agency by agency fight, with the question being, are these actions consistent with the rules, or how government employees are supposed to be treated? And do the actions conflict with Congress's creation of the agencies and endowing those agencies with certain mandatory duties? Second tool the administration has used, make the work as unpleasant as possible, and then solicit resignations. So one small example of that, of course, was the immediate order that all federal employees return to the office, even if there was no space in the office anymore. And then the offer of the so-called fork in the road deferred resignation offer. So this was an email sent to all government employees, headed fork in the road, coming from an unfamiliar email address, saying, among other things, quote, "At this time, we cannot give you full assurance regarding the certainty of your position or agency." In other words, you may be gone tomorrow. In fact, your whole agency may be gone tomorrow. But we offer you the following. You agree to resign now, and you can get paid and not have to work through September. The offer had no foundation in law, wasn't authorized by statute, had no budget authorization underlying the offer that was being made. And it was followed by a whole series of confusing and contradictory guidance. It's not at all clear to this day that the offer is enforceable, and yet, faced with the humiliation, the terror, and the uncertainty, many employees accepted it. And now there's a whole second round of similar offers, agency by agency. The fork offer was challenged by the American Federation of Government Employees, the largest union of federal employees, as well as AFSCME. It was initially enjoined, then the injunction was lifted, and the litigation continues. Third category, the mass firing of probationary employees across agencies. So this was really designed to cut off the civil service system at the roots, right? Eliminate the whole next generation of talent coming into the federal government. And the administration thought, I think, that this was low-hanging fruit. Probationary employees don't have that many rights, as SEMA just said, we'll just cut them all off right now. However, they were so reckless in the way that they did this that it led to 2 federal court actions, several injunctions, and a set of class claims before the Merit Systems Protections Board by agency. Danielle is one of the lead counsel, so I'm going to leave it to Danielle to give us the war stories about that litigation. Fourth category, strip the remaining federal workers of the civil service rights that SEMA described. So this was proposed at the end of the first Trump administration. It was then called called the creation of a so-called Schedule F. The idea is the administration wants to move as many employees as possible out of the protected category where they have just cause and procedural protections where they can only be fired for just cause, and they can contest that through the Merit Systems Protections Board, and into a category where they could be subject to termination at will. Expand the patronage system, contract the civil service system. So now President Trump has this an executive order. OPM has proposed a regulation to implement this plan. Instead of being called Schedule F, it's called Schedule PC, standing for Policy Career. So agencies are at this time evaluating by the order of the President and the Office of Personnel Management all positions to decide which can be shifted over into this new category, which they can argue have some influence on policymaking and therefore can be stripped of their civil service protections. OPM estimates that about 45,000 employees could be reclassified. So instead of that narrow band of political appointees that we expect to change with the administration, we could have a much expanded band of people who have looming over their heads the threat of being terminated on political grounds. So already 5 separate pieces of litigation are pending, challenging this reclassification. They've all been essentially on hold until it's implemented, and there'll certainly be a contest person by person when the individual classifications happen about what the rights are of incumbent employees whose positions are reclassified. 5th category, in order to render federal workers as defenseless as possible against this onslaught, strip them of their right to collective bargaining. Right. So since the Kennedy administration, through executive order, federal workers have had the right to organize and engage in collective bargaining. It was codified in statute in 1978. That statute permits the president to exclude certain agencies and subdivisions of agencies from collective bargaining if bargaining would interfere with national security, if the function of the agency is a national security function, and if bargaining would interfere with that function. So think the CIA. It's been very narrowly and sparingly used by presidents up until this president. On March 27, President Trump issued an executive order that excludes, we think, about 2/3 of federal workers from collective bargaining on national security grounds. The entire IRS, the Bureau of Land Management, all of the EPA, et cetera, et cetera. Now, interestingly, an executive order which excludes based on national security does not exclude Border Patrol officers. Why, you may ask? Because they're strong supporters of the president. And if we thought we had to look very far to see the actual motive of this executive order, the fact sheet issued by the White House, itself says, and I quote, that certain federal unions have declared war on President Trump's agenda. The largest federal union describes itself as fighting back against Trump. It is widely filing grievances to block Trump policies. So this was explicitly retaliatory against the type of litigation we are describing today. Already one court has issued a preliminary injunction in a case brought by the National Treasury Employees Union, halting the implementation of the order. 2 other cases are pending. So what's about to hit us? The 6th category, massive reductions in force. The president has ordered what he's called a reorganization. The Office of Personnel Management has required all agencies to determine how they can reduce their workforce through RIFs, reductions in force. This will certainly lead to litigation, as I've described, agency by agency, as to whether the RIFs are appropriate, given the rules that govern them, and also whether the RIFs are so deep that they interfere with the function of the agency. Take the National Labor Relations Board. The statute only mandates 5 board members and 1 general counsel. So could you RIF all the employees except for the 5 board members and 1 general counsel and say that's consistent with what Congress has required of a National Labor Relations Board? Those are going to be the kind of questions that we're going to face agency by agency by agency. But Danielle is going to try to save us from this agency by agency by agency litigation through a case that her firm and others have just filed, which I'm going to let her describe. So Danielle, take it away.
Thank you, Craig. That was terrific. So 3 themes and 5 ways of exercising those themes gives us a good way to think about what's been going on. Danielle, you've filed not all of the litigation that Craig mentioned, but quite a bit of it. And I want to give you a chance to talk about the cases that are most on your mind. But I thought maybe we would start with the most recent, which is, I believe, the case Craig referenced filed Monday in the Northern District of California, which is a kind of omnibus piece of legislation, litigation that looks at these developments more holistically. So could you describe that litigation and what you're arguing in that case?
Sure, happily. Thank you. And that was really terrific. Both Seema and Craig. Seema, it is, as I know, it is often very hard to describe clearly and succinctly the way that things should work. And you just did that beautifully. And then Craig to also lay out the chaos. But yes, I kind of suspected maybe we'd talk about the new case more before we talked about the has kind of eclipsed the probationary employees case. So on Monday, I represent a coalition, including labor, but not only labor. We've come together with, so AFGE, AFSCME, SEIU are the labor unions that represent federal employees and other employees who are affected by this reorganization and restructuring of our entire government. And they've come together with nonprofit organizations and cities and counties throughout the country to file a challenge that is directed at what is really the source of the problem, the president. And the executive order that was issued in February, the Workforce Optimization Order, it's 14210. I have it up. I've memorized it, as you can imagine, as well as the three agencies that are directly implementing the president's orders, OMB, OPM, and the new, well, we'll just call it DOGE. There's a fight over what that thing is. So we have taken on the implementation of this executive order via those agencies. OPM and OMB issued a memorandum in February that required very quickly every agency of the federal government to submit an ARRP, an agency RIF and reorganization plan. So the executive order talks about RIFs and the executive order talks about reorganization plans, and it mandates both of them. Make no mistake, this is a mandate from the president ordering agencies to engage in large-scale reductions in force, not to consider it, not to exercise their own discretion or authority to do it, according to his instructions, including prioritizing the functions and programs that, quote, my administration eliminates. The president gets to decide what to cut using his agents, and you have to do it. That's your RIF. So OMB and OPM took the RIF and the reorganization, put it together in one plan and said, give it to us in 2 weeks. So by March 13th was the initial deadline for the ARRP, then followed by April 14th. And then they kept them secret. So people have been trying, including unions and others, have been trying to get information about what's going to be in these plans by doing all the things that you do to try to get information from the government, such as filing FOIA requests. Notably, they responded they were pre-decisional because OMB has not made the final decision yet. So people are having a hard time, but as we know, and as Craig alluded to, there, in addition to all of the things that we've seen happening at the agencies, the probationary employee terminations, the fork in the road, the renewed fork 2.0, whatever we're calling the renewed fork, all the other actions that they're taking as part of this, what the president called his policy of transformation of the federal government, radical transformation of the federal government. All of those actions leading up to these April 14th plans, which may or may not have been approved yet, but they're starting to implement them. So we have collected, as part of this litigation, the facts that are known about the implementation and and the time is now. So we sued the president, OMB, OPM, DOGE, and the implementing agencies for which we have solid intel that they are implementing now through large-scale reorganizations and RIFs. And the claims are that the president is acting without constitutional authority to reorganize the government, which I believe in my heart of hearts is profoundly correct, because agencies are creatures of statute. And the Article 2 executive power does not include the power to reorganize the government. In fact, for 100 years, every time the president has wanted that power, the president has gone to Congress and gotten a fast track authorization to do it. President Trump knew about this because in his first term, he acknowledged by putting forward a public plan for reorganization that they needed congressional authorization. They didn't get it. So he's simply chosen to bypass Congress this time. And then he's recruited OMB, OPM, and DOGE to do the dirty work. And so the claims against the implementing agencies, as often are the case with executive order challenges, are under the APA, the Administrative Procedures Act, which you can sue agencies for implementing presidential executive orders under. And so we've sued those. I will resist giving them a nickname. The three, as the central implementors of the executive order, and then also the federal agencies that are on the ground marching in line and saying, we are doing this because the president told us to. We're doing this because DOGE told us how much to cut. So those are APA arbitrary and capricious claims. That case was filed on Monday in the Northern District of California. And we will proceed to litigate that case, and we'll see what happens next. But it is the coalition came together to call this what it is. It's an unconstitutional attempt to dismantle our federal government.
Thanks. That's great. And you did cover this, I think, but I just to be clear, the complaint does such a great job of describing the situation as a separation of powers problem. And so could you just for our broad audience describe how what you see here constitutes a separation of powers problem, sort of one of the core principles of American government?
Sure, no problem. So the basic separation of powers that's reflected in our Constitution is the legislative power goes to Congress, and the executive power is vested in the president. And the courts have long held that the president's power, the president's authority to act, must come from the Constitution or an act of Congress. So Congress can turn around and give the president some of its legislative power, but it can't go too far, as we've seen in cases past. But here, as I explained, they have not reauthorized the reorganization authority. That's a thing. There's a statute that Congress fiddles with every time they do it, and they sort of give broader or narrower reasons and scope of what they allow the president to do to reorganize. The last one expired in 1984. The big prior reorganization prior to that, there have been big ones and small ones, was in 1977 with President Carter. And that reorganization act, which is still codified on the books, you can look and see how Congress defined reorganization, and it includes transferring functions between agencies, but also within, and downsizing and restructuring and eliminating. And if you read it, it's like a playbook for what President Trump is trying to do right now. So that has not been reauthorized. That is expired. He does not have that broad authority. And we, as we lay out in our 100-page complaint, forgive any typos, please, 100-page complaint, that other statutory authority that's been delegated to him by Congress. So this is going to come down to the fight of what Craig mentioned of the unitary executive and the assertion that, I'm looking at the executive order, and maybe some of the audience is familiar with executive orders, and you usually look to the first line, by the authority vested in me as the president. By the Constitution, there's that part's always there. And there's usually a statutory site. By the Constitution and the laws of the United States. There's no statutory site in this thing. So that's the basics. It's that the president cannot usurp the legislative power of Congress by making law himself. And when he seeks to do something like he's doing here, the wholesale reconfiguration, reordering of something that Congress set up, and then specifically to touch on the RIFs, Congress has delegated the authority to employ to the agencies, and the president does not have the authority to fire inferior officers or rank and file employees of those agencies. The president's authority is limited to removing the head of agencies that are Senate confirmed, with some caveats that my co-counsel who are litigating those cases would probably want me to insert here in a very specific way. That there are constitutional constraints on that too.
All right.
Does that answer your question?
Yeah, that's terrific. So I want to also give you a chance, and to you, Danielle, and also to Craig. This is a tough terrain, and there's a lot of challenges, and I want to make sure we have time to talk about some of those challenges. But I also wanted to give you a chance to highlight some successes that you've had already, either you, Danielle, in your own litigation, or Craig, if you want to jump in more broadly across the three themes and five areas that you outlined, like where there have been some at least preliminary moments of success. Danielle, you want to start?
I was going to kick it. I'm now unmuted. I was going to kick it to Craig. So I can start. The probationary employees case, again, a coalition case, intentionally coming together to show the court the range of harm that is being caused, that it's not just the employees who are terminated, who are harmed when we do something like this to our federal government, but it is the people who rely on those services every day, and the organizations, and the state of Washington was a partner in that case as well. Also filed out here in the Northern District. There was a parallel case filed by states in the District of Maryland. So we had a kind of a reverberation happening with two judges issuing injunctions in tandem, and then quickly going up to the appellate courts. And this is, these cases are federal courts. If those law school related lawyers, whoever, people who know what Fed courts is, when we say Fed courts, the class in law school that you take, this is like advanced Fed courts, right? So we sued OPM in that case because we had pretty strong evidence that OPM was directing agencies to terminate their probationary workers, and to do it for performance reasons that were across the board uniform and completely untrue. This massive wholesale firing of probationary workers with no notice was not for performance. They redefined performance to mean mission critical. They can't do that either. So Judge Alsup out here in California said, no statute in the history of ever, or the history of the universe, the quote is something to that effect, allows OPM to terminate employees at agencies. So we've obtained a series of injunctions from Judge Alsup, and they've bounced up and down in the appellate courts. The first was given to the nonprofit organizations, and because their harm was the cut to services, Judge Alsup ordered employees to be reinstated to their positions, not just to administrative leave, but to get their jobs back. And that is what happened at a lot of agencies. They put people back to work because of that injunction. We went up and the Ninth Circuit denied the stay, but then I think a lot of people know the Supreme Court stepped in on the shadow docket and granted a stay pending appeal. But in the meantime, the Maryland court had also issued injunctions and to a broader set of agencies. And then in the meantime, Judge Alsop allowed us to come back for the unions, which he had originally sent to something called administrative channeling, and reversed himself after we implored him to do so. I'll put it that way. Convinced him to reverse himself on it. And that was a remarkable moment, and allowed the unions to go for a further injunction and also the state of Washington to go for a further injunction. So we've got all these injunctions, and recognizing the, one of the, I think, difficulties with this is it's very confusing. It's very confusing to employees. We've got charts and diagrams of agencies and scope. Literally I'm looking because I'm like, I've got a lot of charts, but for an employee at an agency, can you imagine? I can, and for the unions and who represent them, it is exceptionally difficult when the courts are doing this piecemeal rather than what I would say the APA was designed for, which is to hold unlawful and set aside unlawful action in its entirety and it's on its face. That is what the purpose of that statute is. That's the power of the APA. And that is not where we are in terms of the doctrine and the injunctions. That's one of the challenges is remedy issues. We have to deal with arguments about being limited in scope when I think that statute's quite clear as to what should happen.
Okay, great. And as I said, I'll try our best to make sure we have time to go through some of the challenges. But Craig, do you want to highlight some successes? And I have in mind the very recent news about the case involving the revocation of collective bargaining rights. But if you want to talk
I would
about
say
that,
there's been a lot of early successes. The removal of the agency heads have universally been reversed. NLRB, FLRA, MSPB. The only case that wasn't won and it was withdrawn was the removal of the special counsel, which was a bit of a special case because it was a single-headed agency as opposed to a multi-member agency like the NLRB, et cetera. So all those cases have been won, although it gets complicated for reasons I'll talk about in a second. And then many of the agency destruction cases, like the CFPB, as I mentioned. And then, as you mentioned, Ben, very, very important, the recent win by the NTU Treasury employees on the national security exclusion case, because that order literally threatens to destroy federal sector unions, destroy them. So they'll be laying off employees. Because it threatens to take away 2/3 of their membership immediately, because the order is that they're excluded from collective bargaining. Thus, the agencies took the position that their contracts were null and void immediately. Thus, for example, they wouldn't collect dues immediately. So you combine that with the loss of membership caused by all the other actions of the administration, and it's really perilous for the federal sector unions. And so you potentially take the federal sector unions out of the equation and the strain on our ability to respond, Danielle's ability to get sleep. I mean, the onslaught, it's been, quite extraordinary, and we have limited resources compared to the federal government. So, that the ability to hold back that order, at least for a while, was extremely important. But just two things about why this litigation, even when it's successful, is A, very difficult, and B, very hard to hold on to those victories. One is because the actions the administration are taking are immediate. That's not what the rules provide. For example, how's a RIF supposed to be conducted? The RIF rules and the regulations say you need to give 60 days notice, and ordinarily you keep people working. Well, there's a obvious good reason for that. You want to transition, even if you're riffing people at, say, the National Institute of Occupational Safety and Health. Those people are doing important work. For example, they're making sure that PPE, face masks coming into this country are actually work and are not counterfeit. So you want to have a transition where that important task gets passed on to someone else. But what do they do here? They immediately put everyone on administrative leave and they lock them out of the office. So you have to act immediately to stop the damage. The second thing, which is so extraordinary, as Danielle was describing, is it used to be when I was in law school, you couldn't appeal a temporary restraining order. It's not an appealable order. That seems to be no longer the case. So as soon as the district court judge issues an order, the Justice Department goes to the Court of Appeals. If they're not happy there, they go to the Supreme Court. So you have these extraordinarily important cases being decided by the courts on the most expedited time frame. So yes, we've been successful in the agency head removal cases, like at the NLRB, but they go up, and in many cases, they've been stayed. So, we have had some victories, but there's going to be a lot of very important cases lining up on the Supreme Court's docket very, very quickly.
So there are that's helpful, and a way of saying that there are structural and procedural challenges to this litigation sort of across the board that flows from the administration's ability to act immediately and our ability, or the labor movement's ability to respond, and the court's ability to respond in time effectively. I also wanted to give you, Craig, and you, Danielle, a chance to talk about the substantive challenges, the doctrinal challenges that you see in these cases. I think we all fall subject to the problem that when one is litigating a case, it becomes very clear that one is right. But I also want to have a chance to talk about what's difficult here. And what you see as substantive challenges. Danielle, to the extent you're comfortable doing that, and if not, then Craig.
My cases are slam dunks. Come on. No, I hear that, and we would be naive. We would be naive if you don't look at the landscape of the restrictions on access to justice that have been enacted by the federal courts over the decades. That's what I will call them. These jurisdictional doctrines are aimed at keeping people out of court, not keeping people in court. And there are real questions here about how they're being deployed. But you would be naive if you think, oh, that's a lovely constitutional question. I can just go into court and get the court to decide whether the president is acting unconstitutionally. It takes a lot. And so I will say there are practical challenges and there are doctrinal challenges, and I'll talk a little bit about both of them. The practical really, I think, really links with the importance of unions and unions stepping up to bring this litigation and what they have been remarkably doing in terms of leading. Unions are democratic institutions, and so who better to defend democracy than they? But they also have boots on the ground and direct impact and organizational capacity to marshal facts incredibly quickly in a way that helps us get what Judge Alsop called a mountain of evidence. And I, trial lawyer at heart, believe that cases really are not just about these fancy and interesting legal doctrines, but they're about facts and the truth. And we made the OPM case about the truth. Who was ordering that? Who was ordering those terminations? We proved it as a matter of fact, and that from which the legal determinations flowed. But so that's the practical challenges. Their litigation costs money. It's very time consuming. You need lawyers who are willing to stand up, and we all know the context of what's going on right now. And so there's all that. But then doctrinally also, there are these challenges, and I would say they're in a few different buckets. And standing, everyone knows about standing, Article 3 standing has been wielded to keep people out of court. And you know, depending on the court you're in, have to show, you know, pretty tighter and tighter connections with not just to be heard, but also to get the relief and the remedy that you're asking for. And then there are also, you know, that's the front end. How do you get in the door? And then there is the remedy issues and the debate, the hot debate over nationwide injunctions, what are called nationwide injunctions. That's just called striking it down on its face, by the way. So that's just what I would like to call striking something down on its face as an unlawful act, but we'll call it a nationwide injunction, meaning that you get relief everywhere. That you can enforce to help everyone who's been affected by the unlawful action. And that is a very disputed proposition that well, disputed at times. I will say that I believe that the case that was filed, where is that case in Texas, Craig? To enforce the executive order.
Waco.
Yeah, in Waco, to enforce the executive order to apply the national security exemption to the unions. You know, sometimes there's not consistency, I'll put it that way, in terms of what people think about nationwide injunctions. So, you know, there's the front end and then there's the back end. An additional challenge in the context of these federal employees cases is something called channeling. And there's a doctrine that comes out of, it's not only for federal employees. It's not special to federal employees. It's a jurisdictional delay doctrine called, comes out of a case called Thunder Basin. And it basically is an implied doctrine of statutory interpretation where the Supreme Court said Congress set up an administrative agency to adjudicate certain claims. So do you have to go there first? So that sounds a lot like administrative exhaustion, but they don't really call it that in this context. They strip the courts of jurisdiction to hear even claims that are related or can't be brought in those tribunals, such as constitutional claims have been, quote, channeled. So there is a lot of debate about this in the context of federal employees because there are agencies like the MSPB and the FLRA for the unions that do hear certain types of challenges to federal agency action when it affects those employees or unions. The argument we've made repeatedly in a lot of different places now is there are a few different arguments about that. One is whether that really applies to APA claims at all. Another is whether it applies to government-wide action by actors who are not the federal agencies. And there are lots and lots of interesting issues around that I could talk about for a whole long time.
Yeah, we could definitely talk about all this for hours, but I'm noticing that how incredibly fast our time is going. So let me take the opportunity to ask Seema to give her thoughts on some of the challenging aspects of these cases before going back to Craig.
Well, it's just to underscore some of the points that Danielle was making. I mean, in every administration, the first thing that you see the government do, these Justice Department has all of these arguments always written, is standing. Does someone actually have some sort of injury that they can sue? And ripeness, is this actually ready to be adjudicated? So that is something that litigators always struggle with. And then the second point I wanted to make was, you know, a lot of, I think, has been challenging for our brilliant litigators to do in these cases is when you have an entire administration that's really pushing the bounds, you know, to go back to my examples of what you can do with the federal service when there is, you know, say wrongdoing in the workplace. Like they say everything is whistleblowing, you're a whistleblower, you know, because maybe you talked to a reporter, maybe you didn't, but they'll put you on paid admin leave. And before that was something that used very, very rarely, right? Because you're still getting paid. So, you know, a little bit less obvious of an injury, although it certainly could be reputational. But when you do entire agencies or use that authority really to punish people, it's kind of harder to put that in legal frameworks, right? If the president has some authority to say, you know, you can't unionize in this area because it's a national security, you kind of blow holes through that. So I think some of what we see is trying to put these things in norms that we haven't seen tested. Yes, there is executive authority. Does that mean the president holds it all like this? And I think some of that really pushing of boundary testing in terms of legal frameworks, yes, it exists, but people haven't tried to do this before.
Great. Okay, Craig, so why don't you give us your thoughts on the challenges, and then use that as a way of segueing into a discussion of the amazing work you've been doing with the Rise Up initiative, and we'll take it from there.
Yeah, no, thank you. That's what I'd like to do, a little advertising. So thank you. I mean, the challenges are immense. They start with channeling, as Danielle described. So the federal government argues in all these cases, you can't come into federal court. You got to go to these specialized agencies. And the specialized agencies, as Seema described, are set up for a wholly different thing. They're set up for individual cases that happen occasionally, not the massive disruption that we're seeing now. So you tell the employees they got to go to the specialized agency. Some of these agencies have very tight timeframes. You got to take an appeal to the MSPB within 30 days. Thousands of employees are out there with potential appeals, and they all have to act within 30 days. At the same time, the president has taken the head off all of these agencies and essentially disabled them from acting. So a lot of federal employees are thinking, why should I take my case to the MSPB? It's non-functional right now because the president has fired members and deprived it of a quorum. What do? They try to seek counsel for people who work in this area. The problem is that people who really know this area are a very small specialized bar because ordinarily there's not that many cases, as opposed to today where there's thousands and thousands of cases. So the very specialized federal employment bar, while very good, is completely underwater right now. They can't even take calls. They can't even do consultations. They're completely overwhelmed. And then some of these questions are individual. So you have these big probationary cases, and they address the overall problem, but everybody has different situations. Someone may have been misclassified as a probationary for one reason or another. And then you have people who just need counseling. Maybe they were actually correctly riffed. But what's my health insurance? And I've been reinstated, and then the injunction was dissolved, and then I was reinstated again. So like, what is my situation right now? They have no place to go. So we try to respond to that by essentially expanding the pool of lawyers who could do this work, right? At least the basic work of counseling federal employees, going to the MSPB, helping them to understand their situation. So we set out to do that with a whole bunch of partners, essentially by going out to every lawyer of goodwill across the country and said, we'll train you to do this. We'll train you. We'll take some of these experts and we'll explain to you how to do it. And we've trained over 1,500 lawyers now on the basics of representation of federal employees. And then we created an organization called Rise Up Federal Workers Legal Defense Network, where we created technological infrastructure to bring in those lawyers after they've been trained, bring in federal workers who wish to have counseling, and then connect the two. So we now have about 1,300, 1,200 lawyers who are in the network. We've got, unfortunately, more than that federal workers, about 1,500 who've come in seeking legal assistance, and we're matching the two as fast as we can. So my plea is, if you're a lawyer listening to this and you'd like to help, go to our website. We open the doors through our website on the 16th of April. It's Rise Up Federal Workers Legal Defense Network, and volunteer. You can do it. It's not that complicated. We'll train you. You can train yourself at your own on your own time because we have training videos on the website, and then you can really help in small ways, but really important ways. So thank you for the opportunity for that public service announcement.
And thank you. And with great thanks to Seema, Danielle, and Craig. We're out of time for today, but thank you so much for the incredibly informative window into labor in the courts during the first 100 days of this administration.
Thank you for having us.